What's going on? How's everybody doing? Just gonna listen to the end of Phil's stream while he's still streaming, and then we'll get into it. So yeah, I'm just gonna wait for him to actually end, but I'll still be here in chat. Hi, Heather and Heather. Can you guys hear Phil's stream through my headphones or just me? Yep, Rebecca, my first live, very first one. Pat's Cats, welcome. Good to see you. Good to see you. So I wonder how long the delay is. All right, nice, nice. So I'll just keep that in my ears. Once he's finished and he sends people over, I will start my videos. But how's everybody doing? Everybody good? Pat's Cats. I tried to get Demon over here tonight. He must have went to bed already. He's getting old. Ten-second delay, huh? All right. Hi, Lisa. Welcome. Welcome, welcome. Just gonna wait probably 2 or 3 more minutes while Time Served is finishing up his stream. Great Saturday. Great Saturday. How am I doing? I'm nervous. I'm nervous. Got 9 people in here now, so it feels like just a family get together. There's going to be a couple more here in a minute or two. Oh, Rebecca, yeah, it's through Streamyard. There's there's about a anywhere from about a 5 to 10 second delay. You're gonna come calm me down, Heather? Feels really weird calling you Heather. I don't know if I like that. Oh, I'm gonna mess up. That's a guarantee. I'm gonna mess up. I ordered a new mic. It was supposed to come today, and it hasn't got here yet. So I got to use my earbuds. Rebecca, maybe. I don't know what he uses. I have so right now I actually have the live chat up on my phone for this, and I can see the chat in my phone instantly, and it's a couple seconds to pop up in StreamYard. But the cool thing about StreamYard I can do is I can do this. See, that's fun. I can't do that in YouTube. All right, we're getting close. So hopefully just another minute or two. The judge is finishing talking. Or I could just start. Maybe. 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 We'll see. If you're the only one that wants to see it, then no, I can show you later. Lolly's here. All right. 6 minutes passed. Yeah, I think I should start too. I think I should start. Or yeah, no, let's just start. All right. Who votes to start besides Heather and I? Anyone else just want to start? But I think some of you guys are still in time served channel as well. So I don't want two things going on. What's up, Archangel? All right, go for it. I gotta go for it. That's two people. Well, three counting me. All right. I don't. Oh, I've got a couple funny things to start out with. All right, let's go. All right, real quick before I start, I know there's no music on my intro. I was playing with it the other day, and I had a copyright claim, even though I used music from a site that was supposed to be free and to use on YouTube. The second I posted a video, I got a copyright claim. So I haven't fixed that issue yet, but working on it. Working on it.
Hello?
Oh, I'm sorry.
All right, I forgot what was first. This one's funny. There's no judge, no. They're waiting on Zoom. And this is what happens. This happens quite frequently in courtrooms when the court's on recess. Sometimes you'll get some hot mics, but this is a full-on conversation. This did happen a couple months ago, but I just wanted to clip it because I think it's funny.
Sorry, I couldn't hear anything.
I don't know what's going on. I have an appointment with Judge Simpson at 11.
Yeah, me too. I called this morning and I was like, they didn't even have a Zoom ID for me, so I just decided to come to the courthouse. I don't know why they don't have like regular, trial hearings anymore. I just said they're scared of getting COVID or something. I said, what kind of insurance do they have? It's unbelievable.
So
Yep.
Are we supposed to talk?
It's her fault.
Or
Well,
I
I don't
would advise
know.
against it. Just don't. Just don't.
I'm just saying. I ain't heard from nobody, so I mean,
Sorry, I paused it. Rebecca, really? It's clear on my side, but there's things I can do to fix that. I can upload them in higher definition. They're just really big when you do that. And this is I think a 45 to 50-minute video. Even I think I uploaded it at, I don't know, I should remember. It might have been 720p, and this video is 3 gigabytes. So if I would have upgraded it in high definition, it would have been a lot bigger than that. So I don't know. I don't know how to do that. Oh, okay. All right. Yeah, I think I uploaded this in 720. But that's something I can work on. There's a lot of things I'm still messing with and playing with. So if it's blurry, then it's, yeah, definitely let me know.
I ain't heard from no district attorney, no prosecuting attorney. I ain't heard from the public defender or nothing. So somebody got to be talking. I'm sorry. I don't understand this.
here we are.
Oh, that's good. That's good, Lisa. I'm glad.
Because when
I'm
we
glad.
in
Maybe
court,
it's.
it's-
I don't know. I don't know
I
what
was
the
just
issue
like,
is.
don't
then.
come back to the store. So I said, okay. Next thing I know, I'm it's getting hearing papers, arraignment papers.
So, when are we starting?
Whenever the judge is the courtroom.
So you telling me that the judge is late?
Bro, look.
Ooh.
I wouldn't say that on record, but
I'm already there.
I
I
wouldn't say
realized that as soon as I said it.
Oh, it's all good.
Oh, that's great. Great. You had me
That's
panic.
why
there
they're
for a second.
judges. They get to bend the rules. Judges get to bend them a little bit.
Man.
Right. When was the last
They
time
probably
you
no,
heard,
they probably back there still talking and everything.
when was the last time you heard a judge on trial for anything?
I suggest you all put yourselves on mute until you are called by the court. The judge can hear everything you're saying and the courtroom can hear it. So please put yourselves on mute.
I'm not saying this shit.
Yeah, that's why you don't do that. The court is still listening. It was kind of funny though. If I remember right, like I said, this was a couple months ago, and what's up, Touche? And it never got brought up. All these people talking, Judge Simpson didn't bring it up, so I didn't have any reaction clips from him. But it was just a funny interchange while the court was in recess.
Hello. Everybody's just wearing colors that are pop, making them pop. You know?
Well, you know me. I love.
Yes,
I went to school in New Orleans. I love bright colors. And
you have to.
this is the city with Fiesta.
Oh, there you are.
My client wore bright colors as well, Judge. As you
Oh,
can see.
awesome.
So, yes.
I just wanted to throw a Boyd clip in. I thought that was funny. My client was wearing his bright colors as well. That case is interesting, but it involves a child. Not the defendant wasn't accused of anything with a child. It was something else, and it's really interesting. But because it had to do with the child, I'm not going to upload that. I just wanted that interaction, just so you know. But now we get into the fun stuff. Laura, thank you. Thank you for the gifted subs.
Assistant Public Defender on behalf of Mr. Charles Donald. Mr. Donald, please state your name for the record.
Charles Donald, I'm present.
All right. Today is a date and time set for
Thank you, Laura.
sentencing in this matter. So it is.
Let's go.
Are we proceeding today on that, counsel?
Yes, Your Honor.
Okay.
Is time served still
Just to
going?
put it on the record, it looks like the defendant pled no contest on May 17th, 2023 of malicious destruction of a building, $1,000 or more, but less than $20,000. That was
And
count
Shiz is
one
here.
of
Welcome,
the
Shiz.
information.
Thank you for
Count
stopping
two
by.
would be discussed at date. Cobb's agreement, no upfront jail. So is that what we're proceeding on, counsel?
Yes, Judge.
Mr. Donald, I'm going to ask a series of questions. Most of them can be answered by Mr. Feaster, but you'll have an opportunity to address me before I impose sentence. But I do need to start with asking you if you had a full and complete opportunity to go over everything with your lawyer before coming into court so that you know everything that's going to happen today.
Yes, I did.
All right. And so I have had a chance to review the pre-sentence report, also the calculations of the guidelines by MDOC. I've looked through that, and I'll have a chance to hear from Mr. Feaster and Mr. Emmons on whether they agree with those calculations or not. I scored them myself. All of that kind of becomes information to me as far as sentencing. But before we get to that, let me start with the informational part of the report. Mr. Feaster, do you have any additions, corrections, or deletions to that?
No, Your Honor.
Mr. Emmons?
Your Honor, the only issue that I have with the statement, the victim's impact statement, obviously I don't have an issue that you're not in touch with with probation, But however, I think the court should be in possession of, I believe, a victim impact statement was the court.
Yep, I've had it. I've looked at it.
So just, I don't doubt that probation didn't have contact with him, but a victim impact statement was.
Okay, well, I have that. I have reviewed it, and so it is there. Let's take a look at the guidelines. Mr. Feaster, any challenges to those?
They appear to be accurate, Your Honor.
Mr. Emmons?
They appear to be accurate, Your Honor.
From the information in the pre-sentence report and my calculations, they appear to be accurate as well. So I will sign the sentencing information report. And then let's turn back to you, Mr. Emmons. There is a written victim impact statement. Is there any, does Mr. Trapani wish to make a spoken statement today, or is it adequate?
I believe that he just wanted to have that submitted.
Okay. And do you have any comment on probation's proposed sentencing? Mr. Feaster, do you have any comment on the proposed sentencing requirements or any allocution on behalf of your client?
Just some brief allocution, Your Honor.
Okay.
Thank you, Judge. Obviously, I am in receipt of the victim impact statement as well. And I will state that that is one of the best written impact statements I've seen in quite some time, Your Honor. And so I think it really gets to the heart of what Mr. Trapani dealt with, and I'm appreciative of him filing that, Your Honor. I'm also appreciative of Mr. Donald following the court's instruction and getting to a good place with strong internet connection so that we don't have a problem. And he's thankful for you allowing him to appear via Zoom, Your Honor. If the court does recall, he is an over-the-road truck driver, so he is often not in Michigan. That's why some of the conditions in the report say reporting by mail and all those other type of things, Your Honor. Mr. Donald acknowledges that he made a grave mistake in this case by getting into this interaction with the victim in this case. He's apologetic. He's now taking responsibility. He's asking that you follow the COBS agreement and the opportunity to better himself on probation and to prove that he can't comply with the terms. He understands it might be difficult initially to do things
thanks for coming in.
while on the road, but he's committed to doing what he has to do and hopefully getting that transferred to wherever he's ultimately gonna settle at in terms of probation, Your Honor.
Okay.
We ask you to follow the recommendation, Your Honor, and thank you for allowing him again to appear via Zoom, Your Honor.
Okay. Mr. Donald, is there anything you want to say to me before I impose sentence?
No, I have nothing to say.
Okay. This is a bit of a head scratching case, and the victim impact statement does sort of highlight the fact that there must have been something going on, but it seemed to come out of nowhere to him.
All right, you all heard him say he had nothing to say, right? He had nothing to say. Got a sweet plea deal. He's not going to jail. He has nothing to say, right? All right. He just has to sit there and let Feaster talk for him. But yeah, he wouldn't be on this video if he did that.
So I am concerned about that, but if you take care of everything, sir, that's the whole point of this. So that's why I'm not saying. As to count one, what?
He was my neighbor. All this stuff started from a noise complaint that I kept. We was living in Redwood Apartments. If anybody know what Redwood is, like his living room and my living room was like back to back, even though we was in separate places. And I kept reporting the noise complaints I'm like, me and him had.
That's because
I
you are.
spoke with him like 3 times before this incident. Like, I don't care if you
Mr.
say your. I don't care
Mr.
how
Don,
you did his noise or whatever, but it was just the fact that when I came home over the road, like, give me a little respect. That's what all this started from. Like, it just came from, like, not respecting, you know what I'm saying? Like, we both had to share a wall, and pretty much that's how it all started. Like, just from noise that I kept complaining.
I get
about
that.
nobody
So I'm going to
else.
interrupt you, sir, before you get yourself into trouble. So we're going to go ahead with everything, but I just need you to hear me say that I understand that noise is one of those things that can get under your skin and feel like you can't improve it, you can't correct it, you can't do whatever. So even if I take what you tell me at face value,
Welcome, Marshmallow.
like this ongoing problem, you got to recognize that slugging your neighbor in the face and then driving your truck through his garage door is not the answer. You got that?
The truck part wasn't on purpose.
Do you understand what Judge is saying?
I understand what he's saying.
Okay, that's all he's
Yeah,
asking you.
Feaster. Get him, Feaster.
So
Dennis
as to
Rogers'
count
neighborhood.
one, malicious destruction of a building of $1,000 or more, but less than 20,000. The guideline sentencing recommendations are 10 to 23 months in the Michigan Department of Corrections, AKA prison. So that is potentially what was on the table for you, sir. It is the sentence of the court
Yay, thanks, Flying
that you
Monkey.
serve 2 years of probation subject to the following special conditions. Number one, you must not use or possess alcoholic beverages or other intoxicants. You must not bars or other places where the primary purpose serve alcoholic beverages for drinking on site unless the field agent has first given you written permission for your employment at a specific location. Numbers 2 and 3, you must comply with the requirements of alcohol and drug testing.
Hey, welcome everybody. It looks like time served stream ended and people are coming over here now. Welcome everybody to my first live. I'm still new at figuring out how to all these buttons, so we'll figure it out together. But yeah, I went ahead and started because we had people waiting, and I, wasn't gonna wait for that guy. He was being too slow, so I just went ahead and started. But yeah, this guy drove a car through his neighbor's garage, is what happened, and he kept talking. But that's the Feaster saved him from jail.
Directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. Number 4, you must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. Number 6, you must use prescription drugs only as prescribed for you by your licensed physician. Number 7, you must complete the anger management program. That was number 6. Number 7, you must waive confidentiality and allow any treatment program that you're required to attend to disclose information to your field agent. Number 8, you must not engage in any assaultive, abusive, threatening, or intimidating behavior. Number 9, you must contact the supervising physician no later than the first business following your placement on probation or release from jail. More on that to come. Number 10, you must comply with the written, verbal orders made by the field agent.
I cannot confirm or deny that ever happened. Not confirming or denying that ever happened.
Number 11, you must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer, without the need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. Number 12, you must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends, and holidays accepted. Number 13, you must not have written, verbal, electronic, or physical contact with Luke Trapani, either directly or through another person, and you must not be within 500 feet of their residence, school, or place of employment. Number 14, you must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week unless engaged in an alternative program approved by the field agent. You must provide ongoing verification of employment or alternative program to the field agent. You shall not give reason to be terminated or voluntarily terminate your employment
Thanks,
or
everybody.
alternative program unless you first obtain written permission from the field agent. Number 15, you must pay restitution in the amount of $4,140 as follows, payable to Luke Trapani. You must execute a wage assignment to pay restitution if you're employed and miss 2 regularly scheduled payments. Number 16, you must pay a $68 state cost as ordered by the court. Number 17, you must pay a crime victim assessment in the amount of $130 as ordered by the court. Numbers 18 and 19, I am striking, so you pay the $1,611 or the $650. But number 20 does require that you must not use any object as a weapon. You must not use, own, or have under your control or area of control a weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know to possess these items. You must not own or possess a weapon of any type or any imitation thereof, any ammunition or any firearm components. Number 21, you must report to the probation department the next business day after sentencing.
Yeah, I agree, Mrs. Rogers. I should have cut this part out. I'll do that in the future. It was just part of the case, so I left it in. But yeah, this part's really boring. I was thinking that a few minutes ago.
By 9 a.m. So let me just ask you, do you have the contact information for your field agent, sir?
Yes, I've been in contact with her.
All right, so you need to contact her then by 9 a.m. tomorrow morning. Number 22, you may report to the Washtenaw County Probation Office by mail or other electronic method pending acceptance of your transfer. Number 23, you may return to your state of residence once the interstate paperwork has been completed in probation. Number 24, you must pay the $200 application for interstate transfer in the form of a money order before the transfer process is initiated.
All good, Sashina.
Sir,
Thank
you
for
have
being
the
here.
right, I'm sorry, if you serve half your probation and complete the required programming, you may be eligible for early discharge from probation. Your probation officer or you may request that, and it's possible that you'll have a court hearing on that matter. Mr. Feaster will make sure you get a copy of what's called our appellate rights form. You're entitled to file an application for leave to appeal my actions or decisions. The form does explain all the rights that you have regarding your appeal, but urgently or most timely is that if you want a court-appointed attorney for an
I just saw the gifted member. Thank you, Heather West. I don't see it on my StreamYard. I have the YouTube app on my phone, so I saw it. But thank you for the gifted membership. That's awesome. I appreciate it.
appeal, you have to make that request in writing within 42 days of today's date. Do you have any questions for me?
No questions.
All right, Agent Gist, this is a little unusual, but is there anything else that I need to inform him of as far as just contacting his agent by tomorrow morning? Okay. Anything else, counsel?
No, Judge, thank you.
All right, that concludes the hearing, sir. You'll take up everything else now with probation. So if you have any questions, make sure you're in contact with your agent, okay?
Yes, sir.
Thank you, Judge.
Okay.
Mutual property.
All right. I feel like that took a long time. Just the judge reading him what he had to do. That took a long time. But yeah, Mrs. Rogers, I felt it was boring too. But I know I saw what you said, that the judge was yawning. I was bored, and I was wondering why I kept that in. But this is so I had to put a Judge Simpson in. You know I have a thing for Simpson. This happened yesterday. This is landlord tenant, and I don't think I saw anyone else cover this one. So some of you, if you weren't watching them live, may not have seen this yet. I don't know, but it's a good one. Here we go.
Property management versus Robert Beal.
Good morning, Your Honor. Kevin Callahan for plaintiff, P78273. I have with me the owner of the property, Abreet Kaur.
Good morning,
And
Your
this
Honor.
is
Robert.
go ahead.
I'm sorry, Your Honor. Good morning, Robert Beal here, Your Honor.
All right. I had counsel. Did you see a copy of the answer?
That's awesome.
We received a copy of the answer by email
And
at
Jude
4:36
Curio.
last night. It's
Membership
my
gift,
understanding from our
alright,
last
I
court
appreciate
date
it.
that
that was
Mr.
fine.
Beal
That's awesome.
indicated that he was
Thanks,
having
Jude.
his lawyer appear. No lawyer has appeared.
You know, instead of yelling over the voices, I'll just pause it. Thank you for the gifted membership, Jude, for the 5. That's awesome. Monica for the gifted membership. Thank you so much. I shouldn't yell over the video. I'll pause it and say thank you properly. It's more polite to do, I think. Yeah.
On the case, he was required to tender $10,000 into the court's escrow by the 10th of July. I don't have evidence of that. Not to say that it didn't happen. I don't have evidence of it. And he was required to answer the complaint by the 10th of July. And we just received the answer last night that poses 0 legal defenses, Judge.
Mr. Beal, do you have an attorney?
Me too.
No, Steve Wallace will be hired as of next week. The reason I did not put the escrow.
I'm in the most southern south part of Michigan called Ohio. That's where I live. I live in Ohio, but I'm close.
In Monday, as you required me to, and give the answer. My business partner had a stroke in Oregon. I flew to this guy back Thursday night. And my wife has already took the funds out the account. I didn't want her to take that a lot of money up there by herself. So I told her I'd start working on that after I speak with you today.
Thank you.
But we have all of the rent money.
That
up to
escrow was
$19,000.
supposed to be in.
Yes, Your Honor, you're right.
Oh, I know. And all right. And the answer was supposed to be in earlier than it is now.
Yeah, you're gonna drop Cincinnati in the chat. I'm gonna have to pause the video. Yeah, I'm from Cincinnati. I actually live in Dayton now for work, but I'm from Cincinnati. I lived there until my entire life until January of this year. I moved up to Dayton. But yeah, no. Yeah, Cincinnati in the house.
And I don't see where you're indicating that any defenses to the amount they're claiming is owed.
That's funny and
The
probably also
amount
very
they're
true.
claiming is owed. We're off a few $1,000s, but not the majority of the rent, or the 4,500 is definitely due. I have been going back and forth with the management company to do some things around the house, and they have yet to do everything. But the key thing was the deck and the security of the deck. They told me we were going to put a deck up. They decided not to. I asked them to let me pay for the deck. Let me pay for the deck. They said, well, you pay for it. We're not going to reimburse you for it. I said, well, what about if I sell it to you back at 30% after I leave, after the lease is up? They said no. I said, well, if I pay for the deck, can I take it with me?
You know, you're gonna do that. You're gonna say stuff like that. That's fine. I'll take it. I have no beef with Michigan. So Cincinnati is not in this Ohio-Michigan beef. So you can drop that on me if you want. You're not gonna trigger me with Michigan, Ohio things. That's why I don't mind saying I'm the southern south part of Michigan. I live in Ohio. If I said that in front of, people around here where I live, they would freak out because they don't like Michigan and Ohio being next to each other. But yeah, I don't mind. Is it really part of Ohio? We're our own little place. Not really little, but our own place.
When I leave, they said no. So I have been trying back and forth to go back and forth with them to try to work out an agreement with the deck. I did speak with the county yesterday, Steve, the inspector, and he said by law, they're not required to put a deck up, but they are required to have a security barrier back there. So Steve said he was going to call, Steve, the inspector for the county, said he was going to call email the owner to see if they can arrange to put a barrier.
I don't care. You can do whatever you want, Chiz. If you want to come up and talk about it, I don't care. I'll share the stage with you if you want to talk. No shame.
Once that barrier is up, I'm fine. I don't have a problem.
How much is owing on this account?
With court cost, Judge, it's $18,944.23. Court costs are $235.
Hey. Here's what I'm going to do in this case. I'm going to the escrow to be paid. Mr. Beal, we've been through this before. You always make promises to me in another case. You always make all these promises and some excuse, and you're just going to have to put up or not. I mean, I ordered $10,000 in escrow.
Whoa, what did I do? I did not check this apparently. What am I doing? Oh, because here I know what I did. You got to see how many YouTube court videos. Here, look at all this. Look at this. This is what I do when I watch court. Where'd it go? Now I just messed it up. Yeah, this is what happens. I was going to show you all the YouTube tabs I had.
To the escrow to be paid. Mr. Beal, we've been through this before.
I know. I have another court came off mute.
You always make all these promises.
Sorry, guys. I didn't cut this out. I didn't double check this clip.
They said no. I said, well, if I pay for the debt, can I take it with me when I leave?
Okay.
They said no. So I have been trying back and forth.
All right. I'm really sorry, guys. That's a rookie mistake. I should have checked the clip and went back and clipped that out. So what I was saying, I feel like I'm yelling over my video, so I don't know how clearly you can hear me when I'm talking over it. But in another court that I had a YouTube tab open for, came back from recess and started talking. So it got really mixed and jumbled. So I paused it and came back. But now we're like a minute behind. So I'm just going to fast forward like 30 seconds and hope we don't miss that much.
Email the owner to see if they can arrange to put a barrier up. Once that barrier is up, I'm fine. I don't have a problem.
How much is owing on this account?
With court costs, Judge, it's
What's up, Toby?
$18,944.23. Court costs are $235.
Here's
like
what
that.
I'm going
I like
to do
that.
in this case is I'm going to, the escrow needs to be paid. Mr. Beal, we've been through this before. You always make promises to me in another case. You always make all these promises. There's some excuse, and you're just going to have to put up or not. I mean, I ordered 10,000 in escrow. You said you were going to pay it. I get here today. You didn't do it. I don't have any proof of what the other thing.
My name's not Irish Demon. So yeah, that I hopefully that doesn't happen to me. But now that I said it, it probably will.
That you're talking about don't need it, quite frankly. You were supposed to put the 10,000 into escrow. So if the escrow is, so I will grant the judgment. If the escrow is paid, then the judgment will not enter. It needs to be paid today. If the escrow is paid today by close of business, then this matter adjourns out to July 21st, 2023 at what time? At 10 a.m.
All right, this is the last time I'm going to pause it because this is when it starts getting really good. Toby, when I looked into how to do that a few months ago, you could only turn GIFs on and off on a PC. You couldn't do it on the mobile version of YouTube. They might have updated it since then. I don't know. But this was maybe back in March. There were a lot of people asking how to do that, and I just put together a little how to do it guide. And I think that was for Demon's channel. So, but I don't know if they've updated it and allowed you to do that on a phone yet. I don't know. But yeah. But now, yeah, we're gonna play the rest of this case now. No more pausing.
So the escrow needs to get there. If it's not here today, plaintiff's entitled to their judgment for their full amount. If it's there today, then I'll see you guys next week at 10.
Judge, if I may.
I make my orders. You got to follow.
Judge, if I may respond.
Pardon?
If I may respond to that, Judge.
Sure.
Judge, there's absolutely zero reason for us to adjourn this again. Mr. Beal, at our second court date.
Counsel.
If I could.
That is what I'm doing. I don't need a response from you. That is what I'm doing.
Judge, I would like to make a record if I could.
I'd go for it.
Who's that guy?
Thank you, Judge. At the second court date, we received a possession judgment for the full amount. Mr. Beal was not present. Mr. Beal decided to come later on, and the court set aside that judgment. At the subsequent hearing, Mr. Beal made promises to this court, made promises to us that he has a lawyer, he has the escrow, he has this, he has that. He didn't do anything he was required to, and there's zero legal defenses here. I don't understand why we are adjourning it again when there's absolutely zero legal defenses. If Mr. Beal has some kind of misunderstanding about...
Are you done? Are you done?
I'm not done, no, Judge. I'm trying to make my argument for the record.
Get done.
Thank you, Judge.
Get done.
Thank you, Judge. Any dispute about a debt is between the owner and the city and has nothing to do with the legal contract and has nothing to do with Mr. Beal's obligation to tender rent. I have an owner here that has been displaced from her house. She's owed over $18,000 and is not receiving a single dime here. I don't know why you're giving Mr. Beal another opportunity when there's absolutely zero legal defenses.
All right. First of all, part of your record is wrong. And absolutely wrong, because that was explained to you the last time. So don't try to distort the record, counsel. The reason that the judgment was set aside is Mr. Beal was attempting to try to get in. We verified it. In deference to somebody trying to sign into Zoom,
All right, I said I'm going to pause it, but I'm going to pause it for membership gifting. Thanks, Laura.
set aside the judgment. I explained that to you. So don't try to distort what happened. Second thing, I told Mr. Beal this is what he needed to do. He has given me some reason why he did not do it. Certainly, I question whether or not all of that occurred. But what I did is I said, look, if you were to put the escrow in, he files the answer, we'd have to deal with that anyway. He's saying there's a reason why he didn't put the escrow in. I'm giving him till today. to get the escrow in. If the escrow's not in, your judgment. It's as simple as that. That's why that's happening. I'm done. Case over. We'll see you next week or not. Court calls case.
Yes. Yes, Judge Simpson. Get done. Done. The answer is yes. The answer is yes. If a judge says, "Are you done?" You're not. I know he was just trying to create a record so he can, maybe file a motion after the hearing was over. He just wanted to get his words out. But I'm sorry. When the judge says, "Are you done?" You're done. You're done. That's it. That's it. Judge Simpson is a boss. Massive mic drop.
Aston,
that's you.
All right, this is from Reno Justice Court this morning. They're not, you know what? I'm not going to say my conduct is not acceptable. I'm just about to say that. This defendant, I just want to laugh at this guy. I just want to laugh at him. I'm not going to tell you what he was charged with. You can listen to it, but I have a special place in my heart for Reno Justice Court. It's what I do on my Saturday afternoons usually. But this is fun. And then the next guy, I put two guys back to back. The next guy is, again, his case isn't crazy exciting, but it's just his mannerisms and his he doesn't really say anything. It's just how he acts. Like you can see his body language just going crazy.
All right, battery on an officer scores a 5.
Hey, what's up, Michael? No problem.
Well, first,
Appreciate you
sir,
being here.
Mr. Bowman,
Yes, sir.
would you like the services of the public defender to help you on this case?
Yes, please.
Was that a yes?
Yes, please. Yes.
All right, raise your right hand. Do you solemnly swear or affirm under penalty of perjury the evidence and testimony about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, what is your weekly income while incarcerated?
$0, sir.
0?
Yes, sir. Yes.
Okay, I'll give you the services of the public defender, and then we're going to talk about your custody status. Again, battery on an officer scores a 5. What does the state feel is appropriate?
Your Honor, understanding scores a 5. He has no criminal history. However, I think people who punch law enforcement in the face are a danger to the community. I think $5,000 is appropriate. I think he's a danger to the community if he's willing to go that far with law enforcement.
All right, I appreciate that. Defense?
Thank you, Your Honor. I recognize that that is a crime that is definitely not a good crime and not a good look for Mr. Bowman. He recognizes that that was a terrible night for him, and it's inconsistent with his life. I mean, he has no prior misdemeanors in the last 10 years, no prior felonies in the last 10 years. No prior violent crimes in the last 10 years, and no FTAs in the last 24 months. What was your employment status?
Unemployed. Recently, I was employed, but I quit because I just haven't been able to hold a job.
Okay. And lives with his mother and siblings. We called and were able to verify that. Yeah, so at this time, I would ask just for a reasonable amount of bail.
All right. So I agree with the state. Certainly is very concerning behavior. However, he appears in low risk to reoffend, and therefore I'm constitutionally compelled to release him on his own recognizance. And we'll put him on DA supervision, order that he obey all laws, make all court appearances. And July 27th at 9 a.m. is his next court date. We'll see you then, sir. Thank you.
Thank you. Thank you very much.
Oh my God. Oh my God. I did it. After I just made fun of Irish Demon for talking while his mic was on mute, I just did it. I guess that's, something that happens. But I don't even remember what I said. That I was laughing at this guy because he looks like someone who can't do damage to another human being. Like he probably punched him in the officer in the face as hard as he could, and the officer probably just shrugged it off. Like, what are you doing? Oh man, no, your screen didn't froze. My mute button doesn't work. I'm gonna go with that. I did not just pull a demon. My mute button was broken. It wouldn't come off mute. But yeah, so yeah, laughing at that guy. I don't even remember what I was saying anymore. Something about it doesn't matter. The next guy is just very animated. You can see he's upset, but he's kind of just like whatever. But yeah, here we go. I don't know how I'm going to recover from that.
Blanco and then Blunt.
Thanks.
All right, Blanco's here for identity theft, scores 12. What does the state feels appropriate?
Your Honor,
Is this Blanco?
yes, Your Honor. This is, I believe, the fourth open case, or fourth or fifth open case for this defendant. I think the breadth of her other cases, the nature of the other cases, the 12 on the NPRA, I think some bail is appropriate. I know bail's been set on almost all the other cases, but I think bail is appropriate for this case due to the sophistication and nature of this crime spree. So I would recommend, Your Honor, $10,000 bail for this case. I think there is a significant danger for further crimes to be committed when this defendant is out.
All right, thank you. Defense?
I would disagree with labeling this as a sophisticated crime. It's alleged that he took an iPhone and brought it to a pawn shop. With that said, it seems like a high bail to me, given the facts of this case and all the other matters that he has going on. I would request a $5,000 bondable.
All right, so this appears to me to be the fifth. There's 23 SCR 879. That's an identity theft, Cat C, Sparks. 23 SCR 891. A couple, 2 counts of Category D. Credit card fraud.
I'll tell you in a second.
23 SCR 911, another Category C identity theft. In our court, 2023 123794 credit card fraud, and now this case. But in addition to that, defendant scores of 12, which is solidly placed in the higher to reoffend failure to appear category. Therefore, I believe the state has shown by clear and convincing evidence that bail outside of the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant. Bail will be set at $50,000, 50, no contact with the victim, DAS supervision, obey all laws, make all court dates. Next court date will be next Thursday. That'll be the 20th. Actually, I'll do the 21st. The 21st at 9 a.m. We'll see you then.
We can just keep it at 10,000.
Blunt.
All right, I don't know if you heard that very end. He said, "Can we just keep it at 10,000?" Because that's what the state recommended, 10,000. The judge upped it to 50,000. He's like, "I want the 10,000." Yeah, we know you want the 10,000, but no, you're not getting the 10,000. No. How do they decide the number? There's a lot of maybe not a ton of factors that go into it, but it and I don't know what gets you points on the list. I've watched the court enough where if you have a failure to appear for court, you get a point. Depending on if it's a misdemeanor or a felony that you're charged with, there's different points to that. And then like level 1, level 2, level 3 misdemeanor, level 4, level 5, level 6. No, I don't. Why am I saying that? I just got an email. My mind just went blank. But yeah, there's points that go along with all of those. So when you hear 14 points, he probably has a lot on his record. Has a couple failure to appears, but yeah, that's the answer to that. And I just looked, and my mic isn't muted, so that's good. What do we got? Oh, this is again from today. Okay. I want to prep this one. There's a lot of things that I see when I watch in court that I won't record and I won't put up. Like I said earlier, anything to do with children, I won't do it. I might record them just to keep them, if it's an interesting case, and maybe I'll do like a bad guy or a bad person series. I don't know. But another one is domestic violence. I try to stay away from. But this one's actually interesting. And you know what? I'm gonna play this through and pause at the end, so you guys can make your own judgments. Then I'll give you my opinion after it. So it's about, I don't know, 7-8 minutes. So yeah. Oh, real quick. You guys were talking about animals in movies. Yeah, I was following along with that. I have a clip of somebody who's in jail for, I think he was accused with multiple counts of cruelty to animals. And I clipped it because I want to put him on my bad guy, on my bad guy series. It's an interesting case, but he was charged with cruelty to animals. So but yeah, I just don't like bringing that stuff up. All right, sorry. I'll keep playing.
All right, Deputy, which case again?
Number 7.
Okay. 23 CR 004407Y. Rodriguez Hughley, charged with 1 count of simple battery, family violence, pretrial.
Second arrest, last arrest was for obstruction, possession of a pistol or revolver by a person under 18 years of age. He's out on pretrial bond for that. That's it.
All right.
Yeah, Shannon. So this incident took place on May 2nd of 2023, where officers responded to 3144 Martin Luther King Jr. Drive to an injured persons call. Upon arrival, officers were met with the victim, Miss Micaiah Driggles, and her first name is spelled Michiaah. Last name is spelled Driggles, Griggers, who advised officers that her baby's father assaulted her. Ms. Driggles said that she had just got home, and the defendant met her at the front door and said, "You might as well put your stuff down because we are about to fight." As she continued to walk into the home, he punched her in the face in the presence of their 7-month-old son, knocking them to the ground and smashing her iPhone 11. She got away, locked herself in the bathroom to call the police, and he fled. Your Honor, for those reasons, and given his criminal history, the state is going to ask for a $3,000 surety bond and a stay away from 3144 Martin Luther King.
I'll address it.
Martin Luther
It's
King Jr.
inappropriate.
Drive. I do believe that the victim is on, and if the court can sound for her at the appropriate time.
All right. The victim, do you want to make a statement to the court?
Yes, ma'am, I do.
All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Are you in fear of Mr. Hughley?
No, ma'am.
Okay. Do you want to have any contact with Mr. Hughley?
Yes, ma'am. We've already, since this incident, we have contact. We still do for our child, and there hasn't been any problems. And also some of the statement or what Mr. Jones said was untrue as well.
Okay. All right. PD Wills?
Well, if I could ask Miss, is it Driggers? I'm sorry.
Yes, ma'am. It's Micaiah Driggers. I don't know. I guess they spelled it wrong. I'll put the correct spelling if I need to, but
So what exactly happened on May 2nd? You said that there were some things that were incorrect. What was incorrect?
when I came home, we were both upset at each other. We did have words back and forth. It didn't get physical to where he said that he knocked me and my son down. I didn't even have my son. My son was in the house. Me and him were outside having a disagreement. My phone did break. He didn't intentionally break my phone, and I didn't have to lock myself in the bathroom. But
Okay. And all right. Thank you. Thank you. Your Honor, my client is 18 years old. He is a native of Atlanta. He is currently unemployed, but he was making a little bit of money doing odd jobs. He is still in high school and will be returning for his senior year. He has a 9-month-old child with Miss Driggers. He does deny the allegations. He also told me that there was a verbal disagreement. However, things never turned physical. My client states that his mom, as well as his sister, were present and were witness to the incidents that took place. And he also confirmed that there have been no other altercations, verbal or otherwise, since that date. Again, this incident happened over 2 months ago. My client is currently residing with Miss Driggers and their child. They do co-parent, and my client does assist in the care of his child. I would request a signature on bond. And if Your Honor is not so inclined, I would ask that you give him the lowest bond that you're willing to give him in this simple battery case.
Your Honor, if I may briefly, while we don't want to cross-examine the witness, we do want to say that we understand that the witness is recanting. However, the witness did on this particular day tell officers that she was struck by the defendant. She also called police on this particular day. In addition to that, the defendant did flee the scene. So since May 2nd, he has had an outstanding warrant. So he may be a fugitive for justice, Your Honor. For those reasons, we would ask that you keep the bond at the $3,000 surety bond and stay away from 3144 and no further contact with the victim.
And how old is the child?
The child is 9 months old.
And Mr. Hughley is how old at this point?
He is 18.
Still, well, 18.
I agree. I agree with that full-heartedly.
And he's already on a pretrial bond, correct?
3,500.
How much?
3,500.
Okay. All right, I'm going to order a $4,000 surety bond. And with that
Thanks,
surety
Yoga Pants.
bond, I'm going
I
to
like your
order
name.
stay away
I
from
think.
3144 Martin Luther King Jr. Drive. No further contact with the victim. If there is to be visitation with the child, that be facilitated by a third party so that he won't violate the bond by having any contact with the victim.
excuse me, ma'am, Judge.
I'm not finished
She
with
saw
my
your
ruling.
hand up.
I'm sorry.
Also, there's to be no drugs, alcohol, weapons, or guns while on bond.
All good, Stephanie.
And that's going to be the ruling of the court. Yes, ma'am. You had a question about the bond?
Yes, ma'am. Because you said if there was any I'm not in fear of him or anything. Like I said, we've had contact. We co-parent now. We're in the same household. We no longer stay at the 3144 address. But you said something about a third party as far as the visitation for our son. That's kind of hard for us because I'm getting myself together. I have my car. I just got my permit. I'm in the process of getting my car fixed. So there's no, I don't really have close family that's able to do a third party, or I would rather not do a third party because we've been doing well co-parenting. Even after the situation or whatever happened, we've been doing well co-parenting. And like I said, I'm not in fear of him. So I feel that we should be able to co-parent as we've been doing.
Well, there's been
All right. Who can tell me what she just did wrong? She is trying to help her. I don't know if it's her boyfriend. I don't know what kind of relationship they have, but she's trying to help him get out of jail. What did she just do wrong? To a judge, to the prosecutor, what did she do wrong? Anybody tell me? She may have lied, Toby, but that's not the thing that's gonna. Yeah, I don't know. She may have lied, but no. She did open her mouth. She shouldn't have. She did something massively wrong. Minimizing? No. She is minimizing this. And they had a fight where he apparently contact. Oh, thanks, Bogey. Yeah, contact. That's 100% correct. Said that they're co-parenting and living. I think she said they're living together. I don't know, but after a domestic violence charge, he's not allowed to have any contact with her. She's sitting here saying, "I want him out of jail to help us raise this kid," and just admitted to having contact with him. Yeah. Sometimes you just don't talk. Just say, I want him out of jail and I want to have contact with him. It would have been done. That's it. But what you just did hurt him, and you just violated his bond for him. All right, let's finish it up.
incident. There's been police.
Oh, sorry. If I missed your comment, Miss Rogers, sorry. I can only see like 3 or 4 comments on my screen at a time. And yeah, but I believe you. You probably I trust you. You got it right. But yeah, you did.
Police involvement, and there's been a case that's been accused and brought against Mr. Hughley. And I do understand you may have been co-parenting after this incident, but I want to make sure that you and your child will be safe. And I know it may be tough, but I want to make sure that there has been the ample cooling off period, or the fact that you and your baby will be safe. So he's already out on a pretrial bond that he's technically violated. So therefore, I'm not going to give him another chance on another signature bond to get out and violate that bond. So he's got the history that he's not showing himself to be credible to the court. So that is why I am ordering a $4,000 surety bond, and to give it a break and he stay away from you right now. He is to be 200 yards away from you. He did not contact you by any means, cell phone, email, social media. And I would order for him to take some anger management classes, but I won't order it today. That may be further down the road. And just want to make sure that for the future, you will be safe. So since you don't reside on the MLK, I guess there's no reason to have a stay away there. So what will be checked on this bond order will be the provisions where he needs to stay away from you. And those are pretty strict when you read the bond. And that if you're going to allow him to see the child, you're going to have to find a friend, neighbor, relative, or someone who can do that exchange, because if he violates the bond or he's found there with you, he will be returned to the Fulton County Jail.
Okay.
And that would be on a bond revocation because he's violated the terms again. So, use this time to reflect and cool off, get some help and counseling, and hopefully going forward in the future, it will be better. His attorney will know how to file for a bond modification if that is necessary in the future, okay? All right, thank you.
And Your Honor, this incident did occur over 2 months ago. Given my client's young age, is there any way you'd be willing to reduce his surety bond from the $4,000. He states that his mother is also experiencing financial hardships. So it's very unlikely that he'll have any assistance in being able to bond out. And that's a fairly high bond for a simple battery that occurred 2 months ago.
Well, it occurred 2 months ago and then he's been on the run ever since, right?
I don't know about being on the run. He left he left the home. There is no requirement for him to stay. And I'm not sure whether or not he knew that he had a warrant, but I'm not sure that on the run will be an accurate description.
For the same reasons, I think arguing,
else?
hold on, Ms. Driggers. For the same reasons, I think arguing that something has happened 2 months ago is as easily disputable and not really relevant in this context. With domestic violence cases, women often call in crisis. And if someone is not arrested on the scene because they flee, it is often a delayed arrest. So saying that this isn't a big deal and it happened so long ago is kind of moot in this situation specifically. We don't know what happened in the time period, but what we have heard from this victim is that they have continued to have contact. They have moved to a new residence together, and she has now gone from being in crisis and asking for help from police to saying, we want to continue to co-parent together. So something has obviously changed, and that's something we would characterize as intimidation and continued domestic violence in a cycle.
There has been no evidence that there's been any intimidation or anything like that from my client perpetrated upon Ms. Driggers. Someone leaving an escalating situation is not necessarily evidence of fleeing, and there was no evidence presented that he fled. And I never said that this situation or domestic violence is not a big deal. I was just pointing out the fact that this did happen 2 months ago. They have continued to have contact and communication. There have been no other issues. He's very young and he does not have the familial support to help him bond out.
Well, the problem is pretrial. Are you revoking the $3,500 bond?
What you say, Judge?
Are you revoking the $3,500 bond?
Yes.
Okay. So he's going to have other issues, and I just want to make sure he understands how to conduct himself and how to be a good parent and a good significant other to the mother and respectful of her. His history alarms me, and I'm not going to change my ruling. The only thing I will change is to stay away if they don't reside at that location anymore. But I don't want him to have any further contact right now to make sure that they are going to be safe. Next case, Deputy.
Number 8, Mr. Jackson.
Okay.
All right. There we go. I don't think I have anything else after that. Yep. Nope. That was it. That was it. Yeah, I don't know if it was a prosecutor or what her position was, but she nailed it when she said that they were still having contact, and she went from being in a crisis / victim to sitting here trying to get her boyfriend, or I don't know what their status is. She's absolutely right though. And I get trying to get someone out, trying to help and getting someone out of jail. But you can't say that you're defending them by throwing them under the bus at the same time. She did a lot more harm than good, and I don't understand why she was in that situation to begin with. But yeah, that's it. That's the stream. That's all the clips I have. I mean, I could play another video, but it's been an hour, so we can end it. If you guys say you want another video, I've got clips for days. But yeah, people are leaving. I can already see the number dropping drastically, so people think it's over. But tell me, you want me to play a random video, or you want to just call it a day? More. Thanks, Laura. Thanks, Heather. It's still weird calling you Heather. I think I can count on maybe. For you that don't know, Heather and I, that's my girlfriend. Together for a long time, and I don't know how many times I've actually called her Heather. So it's weird. All right, you guys want more? Let me. I don't have anything clipped and ready to go, so I'm gonna have to fast forward some stuff. Let's see, what do we got? I mean, I just played that. You know what? I'll play the Judge Boyd clip from the beginning. That is a really interesting case, so I'll play that. And we all love Judge Boyd. Let's get it. Play Shiz's trailer.
Hello, everybody's just wearing colors that are pop, making.
All right, didn't mean to do that. What Shiz trailer? Did I miss something? Shiz, you're here. What did I miss? Shiz, do you wanna play something? Oh, you sent it to me. All right, I just got it. It's on YouTube. I've got to download this. I don't know how to play this from. It's not letting me pause it. I don't know how to play this from StreamYard. Yeah, I got it. I clicked on it, but I don't know how to play it from StreamYard. I don't know how to screen share to my browser. Let's see. Can I present here? Extra share screen. All right, let's do it. I'll do it. I think I got it. Yeah, we're all learning together. You're gonna see my screen. So yeah, I don't care. Share screen. Guessing that's it. All right, I don't know what you guys can see. Can you guys see this? Oh, I honestly don't know what you can see. All right, I'm looking at my phone. Can you guys see my screen right now? No, thanks, Lisa. I did, didn't I? This is, for whatever reason, this is full screen. It's telling me to exit full screen here. All right, this is gonna good as we're gonna get right now.
Pop.
Yep. I don't know what's going on right now. No idea what's going on right now. So many things clicking and going through. All right, I think we're back. Sorry, I was reading what Shiz just said. All right, yeah, no, that's cool. I just figured out how to do that. I don't know what that's about. Do you want to come up and talk, or do you want me, or I can play this next court video and just show the Judge Boyd clip that I think is really interesting, or we can call it a day. Up to you guys. Valerie, welcome. Oh, yeah. I got to figure out how to do that. I figured out how to highlight comments, and I figured out how to share my screen in one stream. So this is a success. This is a success. All right, that sounds good. We will. You do realize this is a weekend. This is a weekend. Maybe. Am I missing work right now? Is that just me? What's going on? What's going on? I don't know. I don't know. All right. All right, just keep playing for 5 to 6 hours. All right. All right, well, I'll play this one. This is a slight trigger warning before this. It involves somebody touching a child. It's not this defendant. He didn't do it, but it's his child, and he's in jail. So they ask the judge for leniency on sentencing so he can get his child away from this situation. And I have 2 girls. Those are 7 and 8. Well, now, no, they're 6 and 8 right now. 7 and 8 in a week. But if I ever found myself in this position and I was in jail, I would be trying to jump through every legal hoop I could to get out. And that's what this guy's doing. And I applaud him. I don't remember what he's in jail for. I think it has, I actually don't know. I actually don't remember what he's in jail for, but it's kind of heartbreaking because he's trying to be a good father, but he's in jail and you can tell he just wants to go murder somebody. Am I still screen sharing? All right, I stopped it. I saw the banner up there. All right, let's go.
Well, you know me. I went to school in New Orleans. I love bright colors. And
You have to.
this is the city with Fiesta.
Oh, there you are.
My client wore bright colors as well, Judge, as you
Oh,
can see.
awesome.
So, yes.
So what are we here for?
Judge, I confirmed with probation earlier, and apparently because of some past affiliations, he's not eligible to go to ISF or DDRF.
Mm-hmm.
And so there was going to be a recommendation of sending him to ISF,
Okay.
Big State ISF. And Judge, just to let you know, my client's been in for nearly a year and in the county jail. More recently, though, he just learned that his 11-year-old daughter there's a CPS investigation going on involving the daughter that another man might have touched her inappropriately, done some things. So my client is very upset about that, as you can imagine, and is asking if there's any chance he could be out at least for a little while to try to see his daughter and be with her while this is going on.
Right. Well, one, I need proof of the CPS case. Oh, look, he came prepared.
I'm just learning of this morning too. So.
Oh, well, Mr. Kuntz, if you want to look at it and review it and.
I think I already said thank you, Lisa. I don't know. I remember seeing it, but I was clicking through things. But yeah, thank you for this.
Okay. Thank you.
Thank you.
All right. Probation, are you aware of the open CPS case? All right. And I'm assuming that this is involving someone other than your client.
Correct, Judge. It's apparently his daughter has a sister that is not his biological child. The father of that child that's accused of perhaps being inappropriate with his daughter, right? Yes.
All right. So probation, he was waiting for transfer for drug treatment?
Your Honor, so he was ineligible for DDRF or any of our local facilities due to previous involvement in a gang.
Mm-hmm.
So the TAP was it was redone and they are now requesting state ISF.
All right. And so I see where he pled on this case, May 23rd.
Was sentenced probably May 23rd, right?
Yes.
Yes.
And what is the wait time for
too.
the ISF?
Your Honor, the wait time is going to be approximately 30 days.
Okay. And we're sending to ISF because of mental health issues or?
State ISF will address any substance abuse or mental health issues.
All right. let me see if I can.
And Judge, from my perspective, Mike, having known my client now for some time and representing him, he has struggled with substance issues for some time. And in fact, every arrest he's ever had has been as a result of substances. And so for his long-term well-being, I think he does need counseling, whether that's outpatient or inpatient. My client would obviously ask for outpatient right now.
What is his criminal history? Because I don't have that.
Your Honor, on your court summary, on page,
Okay, let me
I think
see.
it begins on page 2 and goes on to page
That
3.
one I don't have. No, I have.
Under, it's gonna be under SR, the SRs.
Okay, thank you. Let me go to SR. And which page did you say?
Go to page 2 and page 3. You do have probably 2 Martinez's.
Yes, I do. Okay. So I can't send him to felony drug court since he's already been denied.
Judge, refresh my memory, was he denied because of the prior gang affiliation?
Yes.
Okay. That's what I thought.
All right, this is what I'll do. I will have him sent to ISF defense if you want to talk to felony drug court and explain about the gang affiliation, whether he's still in it or not. You're more than welcome to do that. And if you're able to have felony drug court accept him, then that's fine. But I'm going to recommend then that he go to ISF. And the reason why, Mr. Martinez, you do have a drug issue, because I never would have recommended you for felony drug court if you didn't. And this whole child protective service case that you have, I've done plenty of those. I think your attorney has experience with those as well.
I believe this.
Regardless of what's happening, they're going to want you to have treatment too. And sometimes you're on better footing if you have treatment. They're not going to terminate your rights normally if it's because you're in inpatient treatment. You understand?
Yes, I was just worried about if her mother was gonna continue to have custody of her, and if she wasn't, then I don't know. I don't really know what's going on. I'm in the dark about all this. So,
well, normally you should have an attorney on that side if they're opening up a legal case. And what they will do is, even though you're in custody, they're supposed to actually have you brought over, or have you by Zoom for any hearings that they have. And if you have an attorney for you over there appointed to you, they're supposed to come see you. Okay. But normally in cases, I don't know the specifics of yours, but normally in CPS cases, what ends up happening with those type of charges, they do their investigation. They will ask both parents if they have someone that the child can be placed with. Because if those allegations are to be found true, normally they don't place the child back with the parents until after a service plan has been completed, and they think that all of the dangers have been alleviated. Sometimes in cases like that, they may return the child to the parent who had the child when the allegations are alleged to have happened, but they'll only do that normally if the person who's accused of committing the offenses are out of the house and that person has no more contact with them. Okay.
and I think one of my conditions was I wasn't able to have like any kind of custody of her. I think, or if I heard wrong, I don't know if I heard.
I'm sure there may be no contact, but you're able to speak to you about that. And that's something that if you are completing your service plan, if there is a service plan that results from this, your attorney can always come in and ask for different conditions to be changed.
Okay.
All right. Is there anything
There
else?
are no contact orders as a result of this case that he's on.
I
probation?
don't think so.
I don't believe so either.
Let me see what I've written. There are no contacts with several people. And probation will be able to tell you the names of those people. I believe this is a Pizzuto. And
Damn right I am. Yes, absolutely. I'm a Bengals fan. Hi, people in court. Thanks for stopping by.
Sanchez, but they'll be able to give you the exact names.
Okay, so he's good. Thank you, Judge.
All right, thank you. So we'll do probation. He's the remaining custody. We'll do the state ISF. And counsel, if you want to talk to felony drug court and explain and see if they'll accept him. If they do, then he can go to felony drug court if they accept him.
Okay, I'll make one more.
Do you do it, both tracks? The substance and cognitive?
Yes. All right, is there anything else?
No, Judge, I'll make one more pass at drug court.
Okay,
Thank you.
you're welcome.
Yeah, we already watched this one. I clipped this one at the beginning of it. But yeah, that was hard to watch. That was hard to watch. And no, I'm not an Indians fan, Lolly. I'm a Reds fan. Cincinnati. Reds, Bengals. Stephanie, that's probably the worst thing you could have possibly said to me. I'm joking, but not really. Hi, Diver Dan. So what do we want? That's all I have that's clipped. So if I play something else, it's either going to be something from my YouTube channel that's older, or people in court. That's awesome. Or I'm going to be picking some random recording that I haven't gone through yet. So, I mean, you guys tell me what you want, but not the Steelers. We're not doing that. Laura, no, we're not doing that. We're not doing that. Don't make me take your wrench away, Laura. I would rather you say Browns or Ravens or anybody else but the Steelers. Just play the Bond Court videos. I'm not just going to go to Bond Court and just live stream his channel. It makes me feel better that I clip them and cut them and then make a video out of them. I don't just want to go to his channel and just start streaming his stuff. I don't want to do that. I think, yeah. All right. I do want to do one thing. There's still 20 of you here. This is a good turnout. It's been an hour and a half. I'm going to do one more video, but I'm going to play an older video that I posted. One of my first videos I ever posted that doesn't have a lot of views. And yeah, I can. People in court, I can play stuff I haven't gone through, but it might be just random, just nothing's going on. It could be an hour-long clip that I just haven't gone through and clipped out. Yeah, Jashina, I could do that. But now that I know how to share my screen, let me do something I probably shouldn't do and recycle content, because I'm going to play you an old video that I think is hilarious. At first. All right, here it is. Now, I know you guys can't see it. I'm bringing it up on my screen. All right. Hey, Brian. Thanks for dang. Hey, what am I? Why am I confused all of a sudden? I saw Brian's name pop up. I got excited and I got confused. We like funny videos. That's what I like to hear. How did I do this again? It tells me what tab it is. All right, sorry. I'm still learning. It takes me a while to do this. All right. This is one of my favorite Judge Simpsons clips. Hopefully you guys can still hear me. I don't think I'm muting my mic. But Muhammad is the guy that we're looking at. You can clearly see that he's busy practicing his craft.
The 14A District Court for the County of Washtenaw, State of Michigan is now back in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
Court does call the case of the people of the state of Michigan versus David George Manny II.
Rob Dowden to have the people.
Oh, wait. Did I just cut the haircut out?
Good morning or afternoon now. Lydia Fields, Assistant Public Defender, appearing on behalf.
Okay, what are we doing?
Is he here?
Mr. Manny, can you unmute and state your name?
He's here.
David Manny.
Oh, there he is.
All right, what are we doing?
I think we have a plea that was submitted. Please tell me you have one.
Was that today?
Oh, I sent it to Miss Fields. Did she agree to the plea or?
I did. I thought you had forwarded it on. My apologies.
I said
Forwarded to who?
To the court.
Okay, I don't have it. All right, look, people, this is the third one today. These have got to get to they've got to get to us so that we can process them so they can make it to my file. This conference will be adjourned. And my clerks, thank you for the additional work. September 15th, 2022, 9 a.m. Bond continued.
Thank you.
Thank you.
Kamahamid. Kamahamid.
Court calls case, People versus Candace Hale.
What am I doing?
Name is
Why do I
Ganatra,
have so
First
many-
Assistant Prosecuting Attorney for the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Hale, Your Honor, who should be present. I have spoken to her a couple times today. Ms. Hale?
Yes,
There she is. State your
Okay.
name, ma'am.
Candace Hale.
All right, what are we doing?
Your Honor, this matter, this is a matter that Mr. Ganatra and I have agreed to submit an application to the mental health court. I have completed that form. I just need Ms. Hale's signature on it, and I can forward it to Your Honor for signature as well. I'd ask the court to adjourn it 2 weeks to let her be screened. Your Honor, Ms. Hale did want me to let you know that she's her parenting classes are going well, and she is gainfully employed and has been for a while.
All right, very good. Okay, I'll adjourn it out to the 15th, September 15th, 2022, 9 a.m. And because I didn't say so, Mr. Gaddy, because you were not here with us, it's good also to have you back, sir.
Thank you, Your Honor. It's good to be back.
Court does call the case of People versus Courtney Hall.
You're all set, Ms. Hale.
Thank you, Ms. Hale.
Rob Dowden to have the people.
I kept this going long for, I don't know.
Calvin Hawthorne, Assistant Public Defender on behalf of Ms. Hall. Ms. Hall, please state your name for the record.
Courtney Hall.
Your Honor, I would ask for a 2-week adjournment. I think we have a HIDA resolution.
Probable cause will be adjourned September 15th, 2022, 9 a.m. on all cases. Bond continue.
Thank you.
Thank you.
Court calls case of the People versus James Hill.
Lou Danner for the people.
First Assistant Public Defender Kalina Anderson with on behalf of Mr. Hill. Mr. Hill, please state your name. Muted, Mr. Hill.
Oh. Thank you, man.
You're right. I was gonna ask if you had the plea form, but I thought it might be too soon.
That's why I kept this in here. That's why.
that was good.
Mr. Hill, if you can unmute and state your name for the court.
James Hill.
Your Honor, I have been in contact with Mr. Hill. There is a misdemeanor offer. We're still in discussions on that. I would just ask for a brief adjournment to continue to talk to my client.
Yes. We'll do.
That's something I would have done.
September 15, 2022, 9 a.m. Bond continued.
Thank you, Your Honor. We'll be
Laura, I
Mr.
saw
Hill.
that.
Thank
I
you.
saw that, Laura.
I'm all set.
Yes, you're out. Thank you.
Yes, sir. Yes, sir.
Okay. Have a nice day.
We were done a while ago. All right. Court calls the
We were
case.
done a while
People
ago.
versus Javon Hurston.
Name is Ganatra, First Assistant Prosecuting Attorney for the People.
Calvin Hawthorne, Assistant Public Defender on behalf of Mr. Hurston. Mr. Hurston, please state your name.
Hurston.
Thank you.
All right. What are we doing?
Your Honor, I'm asking for a 2-week adjournment. Mr. Hurston and I spoke briefly about his case, and he would like more information before deciding whether to go to the felony drug court.
All right. Well, why don't I do this? I'll just go to the 22nd on this one. 2022, 9 a.m. Bond continued.
Thank you.
All right. Thank you. Court calls the case versus Mohammed Ibrahim.
There we go.
Blue banner for the people.
First Assistant Public Defender Clinton Anderson with it on behalf of Mr. Ibrahim. Your Honor, you should, I pray, have the
I will say
form in
that,
this one.
I know you have a plea form in this case. Your Honor.
And I know you have the police report, so we should be good there, Mr. Banner.
It's a
My
miracle.
client is here. He's occupied, but he's here.
He is working, enjoying, exercising his craftsmanship right now.
He's cutting hair.
I believe he's getting a haircut there, Judge.
Oh, he's the one in the chair?
No, I'm cut.
Oh, okay.
Oh, you're cutting.
Can you take a break there, Mr. Ibrahim?
Yeah, sure.
Okay.
And Your Honor, this is a no contest plea, Your Honor, to a youth, and as fast as we can get through this, I know Mr. Ibrahim and his client are eager to finish that job there.
I was looking at that. It looked like,
I would agree.
it looked like he messed up that right side. But anyway, I ain't gonna say nothing. All right, Mr.
I
Ibrahim.
take no responsibility for what kind of haircut he's getting.
No,
Y'all in a good mood this morning, huh?
it didn't look right. I'm just saying. Didn't look right to me.
Well, I'm gonna wait till after.
I'm still able to judge that.
I'm gonna wait till after I get sentenced to
He's a smart man. All right. All right, sir. Can you please raise the plea form that's actually here indicates that the defendant will be pleading to a controlled substance use, the 1-year offense. And on his successful no contest plea to that charge, the felony would be dismissed. That is the court's entire understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor.
All right. Sir, could you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record, please, sir. Or not. He froze.
Mohammed Ibrahim.
Okay, No.
I'm here.
Yeah, you're gonna have to stay in one spot because you're.
Yeah, I see that. If Your Honor, I would have a problem if we turn this video off at this point.
Okay.
Finish.
I don't know if we want to turn the video off because I want to see what he's doing to that hair. But anyway, never mind. Shut the video off and let's see. All right. Can you hear me, sir?
Yes, I can.
All right. It's this court's understanding that you're going to plead no contest to the charge Mr. Ibrahim, I'm gonna have to have you someplace quiet. Mr. Ibrahim?
Yeah, is that fine?
I need you someplace okay, that sounds good. All right.
Okay.
You're gonna need to hear. Am I hearing? Okay, I'm thinking we're good. All right, you're going to plead no contest to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. You understand that, sir?
Yes, I do.
You understand what a no contest plea is?
Yes.
All right, let me explain two things about it just to make sure that you understand. First thing about it means that you're not desirous or wanting to contest this charge. You understand that?
Right.
The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yeah.
All right. You also, sir, need to understand, is this if city?
It is ours, actually.
It's mine. Okay, so I don't have to, but it's my case. All right. So that's why he wanted to wait till after sentencing. All right. All right, sir. So, sir, and the basis, Miss Anderson, for the no contest plea.
Lack of sufficient memory, Your Honor.
All right. So, sir, to the charge of use of a controlled substance, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yeah.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial, or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself, or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a doubt. You understand all of that, sir?
Yes.
You understand you're giving up your right to appeal of rank.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yeah.
Of your own free will?
Yeah.
All right. The court has been provided and has reviewed Washington County Sheriff's Office report for their case number 21-24433. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be September 14th, 2022, 9 a.m., and that is before me. Bond will continue. All right. Thank you, sir.
Thank you,
Your Honor.
Thank you, Mr. Ibrahim. I'll send you an email shortly.
All right, thank you.
All right, there we go. Mike's in. Sheena, I need to make you a mod so you can drop me that link and then I'll just share it. There we go. I said Sheena, Sashina. Sorry. Yeah, that video was one of the first videos. And I thought it was hilarious. And this was back when I was kind of a fanboy to Law Talk with Mike, and I kept trying to send him content, and he never used my clips. He started using my clips, but that one was one of my favorite, and no one used it. I don't know why. The guy's getting, guy's cutting hair in court. Everyone's laughing. There was a joke beforehand because there was a prosecutor or a defense attorney not actually submitting plea forms to the court. So you saw Judge Simpson was frustrated. because it happened all morning. People just like, oh, you haven't got that yet? I submitted it. And so he's frustrated. And then Kalina Anderson, who is the chief public defender of that court, came in, and it just made him laugh so hard. And yeah, it was good. It was a good clip. It was a good clip. All right, what do we got? Let's look at comment. Let's look. I see it on my phone, but I gotta wait till it pops up on my computer. All right. Now, all right, why can't I click on it? I can't click on the link. Do I have to go to my own YouTube live? Because I can't. The only thing I can do in StreamYard is, yeah, I'm actually gonna have to go to my own live on YouTube. Yep. Now I can hear myself talking. All right. I got it. And not saying I don't trust you, but I'm gonna just kind of scroll through this real quick. I love that it's all right. This is perfect. All right, we're good. All right, let's see. Go back. Shut this again. Who's ready to see some Judge Boyd purses? Got a minute long of Judge Boyd's purses. It's the one that's just Boyd? Yeah, it has to be it. All right. Did I do it right? All right, who's ready for some purse love? Oh, yep. This is what I've come to. Showing off purses. But yeah, thank you, Sashina. I know a lot of people are gonna like this. I'll put your link to your channel in my description for this video. But here we go. All right, that was. I know Heather really enjoyed that. Every time she sees Judge Boyd, all she talks about are the purse and flowers, which was the inspiration for me to put the Judge Boyd clip at the very beginning of this video. But yeah, it's been almost 2 hours. I think we gotta call it. I know there's still 20 of you guys here, and I love it. But this is getting long. And yeah. Yeah, you probably did. I haven't seen the same bag 2 days in a row. So yeah. All right, I'm calling it a night for streaming. all I'm going to be doing is recycling content now. But I appreciate everyone coming. I appreciate everyone coming. But it is time. It is time. Thank you, everyone, for coming. Now I'm just repeating myself. See, this is why I gotta go. Because now I'm not even saying anything relative. But yeah, this was fun. This was fun. I was gonna show my face, but I think I'm gonna hold off. I'm gonna hold off, and I'm gonna make that like a reveal thing. I know Heather really wants me to show my face, but I'm gonna hold off on that. Why are more people coming in? There's supposed to be people leaving because I'm saying bye, and now the number's going up. All right, now it's going down. All right, now I don't feel bad. All right. Yeah, yes, people in court, I agree. I'll have a reveal. You have my animated picture on the whatever and my icon, so you can see what it looked like animated. All right. I am out of here. Thanks again, everybody. Thanks again. I appreciate it. Till next time. Bye.